for abuse of office. Section 11 of the Anti-Corruption Act 2009 provides for offense of abuse of office. Under subsection 1, a person who, being employed in a public body or a company in which the government has shares, does or directs to be done an arbitrary act prejudicial to the interest of his or her employer or of any other person in abuse of authority of his or her office, commits an offense and is liable on conviction to a term of imprisonment not exceeding 7 years or a fine not exceeding 168 currency points or both. The state has to prove, therefore, the following elements. These elements, you all demonstrated them in the submissions. But herein, they shall be: A, accused were employed in a public body or company in which the government has shares. We have to determine that fact. Were they employed in a public body? 2, or B, accused did an arbitrary act in abuse of their authority. Did they do an arbitrary act in abuse of their authority? C, the arbitrary act done was to be prejudicial to the interest of their employer. Refer those elements in the case of Uganda versus Rwamafa Jime and to others, criminal section number 9 of 2015 at page 15, reported on Yuli. For the charges of causing financial loss, they include counts 2, 4, 6, 8, 10, 13, 15, and 17. Section 20 of the Anti-Corruption Act 2009, as amended by Act 21 of 2015, provides that 1, a person who does or fails to do an act knowing or having reason to believe that the act or omission will cause financial loss to the government, bank, credit institution, insurance company, or public body commits an offense and is liable on conviction to a fine not exceeding 330 currency points or to a term of imprisonment not exceeding 14 years. The following elements for causing financial loss. These you have equally demonstrated in your submissions. But for this point, you take the following. 1, that the accused were employees of government. Is it so? 2, that they did or omitted to do an act they had knowledge would cause financial loss. Did they do so? And 3, that the loss was occurred. Did the loss occur? And confirmed to be civil servants, stock employees under the Ministry of Lands deployed at Wakiso land offices as per Prosecution Exhibit 10 to 15, with roles as assigned per Lease Land Information System application forms admitted as Prosecution Exhibit 3 to 8. The accused in their respective defense testimonies and in the final submissions by their respective lawyers admitted to have been employed as per their description in the charge sheet. For that reason, I find the state to have proved this element of the offense in all accounts against each of the accused parties. All employees at Wakiso Emzo, your employment letters were presented. Land Information System forms were also presented to indicate, yes, you had obligations therein. Besides above, the state has to the case of Andrua and another versus Uganda. Criminal Appeal number 17 of 2016. An arbitrary act was defined. to mean an action considered to be an act founded on prejudice or preference rather than on reason or fact. It is an action or decision that is based on personal will or discretion without regard to the rules or standards. It is a decision that may be made outside the existing law or procedures. The arbitrary act or omission must be done willfully. You must not be forced. So whatever you do, it should be according to your personal will. You take your own decision. You don't follow the procedures. That is what would amount to an arbitrary act according to that case law. While a prejudice is damage or detriment to one's legal rights or claims as per Black Law's Dictionary, 8th edition of 2004 at page 3738. That's what prejudice means. In the instant case, evidence alluding to the arbitrary act prejudicial to accused employer in counts 1, 3, 5, 7, 11, and 12 are that accused persons 1, 2, 3, and 6 processed and registered mortgages without verification and proof of payment of stamp duty. It's also alluded that A3, 5, 4, and 6 in counts 9, 14, and 16 processed and registered mortgages which had not been formally received at the customer care desk and without verification of stamp duty. You have to understand the two sets of offenses. The first one, which I'm saying, the charge is basically based on you processed, it's alleged you processed and registered mortgages without verification or proof of payment of stamp duty. That is the first set. And it is in respect of A1, 3, A1, 2, 3, and 6. And the second set still, which is in respect of abuse, which is against A3, 5, 4, and 6, and these are counts 9, 14, and 16. It is said that you registered mortgages which had not been fully received at the customer care desk and without verification of the stamp duty. So you must have received the documents. There's no proof that they have been received. But the first set is that, yes, you received, you worked on them, but there was no stamp. You did not verify the stamp duty. That's what simply it means, that sets of cases, how they are drafted. It's the prosecution evidence that because of the acts of accused, financial losses as described in evidence presented above was occasion to the government. I've already described what the state mentioned. Before I proceed, I need to mention that these multiple charges against accused, in my opinion, presented only 3 questions. The question for me is whether accused had the duty to verify taxes. 2, whether accused had the capacity to verify the taxes. And 3, whether A3, 4, 5, and 6 processed and registered transfer instruments which had not been formally received at the customer care desk and without verification of payment of stamp duty. These are the questions to be responded to in determining the culpability of the accused persons. To prove acts of prejudicial, state relied on the testimonies of PW2, 3. The reading of their evidence was that accused did perform their work well. These 3 first witnesses who were closely supervising the accused, because there is senior supervisor, there is a registrar, then there is a commissioner. So the reading of the evidence was that Achus did perform their work well, that no report was made to them about any arbitrary acts by accused persons, that no disciplinary act was ever conducted against any of the accused person, that the procedure for registration was followed as per the practice directions and manual issued from time to time, that LIS, or Land Information System, was a new application and not all accused had been trained. These are the senior 3 officers who are describing what happened at the EMZO. That not all staff were connected to internet to access URA portal, save for A2, who was connected between URA and the ministerial zone office. That the customer care officer, who is A2, role was to acknowledge receipt of documents for registration and receipt of acknowledgement issued. He was to verify whether fees for stamp duty and registration fees had been paid, that no complaint was received against any of them. From URA, that any revenue had been lost. As to associated mortgages, it was that no fresh fees were supposed to be paid, but only proof of stamp duty was to be presented for registration of subsequent mortgages in another EMZO. The process of registration was to be followed, and the deposit was to be at the customer care desk and an acknowledgement issued. The customer care officer was responsible for verification of stamp duty and registration fees and the accompanying documents, and thereafter scanned, reviewed by the registrar before it is passed. This evidence was consistent with the defense testimonies. However, what was unresolved is what amounts to verification for the customer care and the registrars. What does it amount to verification as it relates to their work? It was a new set of facts that was brought on the issue of acknowledgement. It is draft verification. It is drafted in the charge sheet, but it is not reflected in any of the roles played by them. Verification is a statement which is in the drafting of the charges, but it is not provided in any of the roles of the accused person. So here, what amounts to verification for customers, customer cares, and registrars? Verification of documents and verification of payment of taxes. There's issue of verification of documents, then verification of payment of taxes from URA are 2 different variables. Clearly, it has been demonstrated through prosecution witnesses that all staff, save for customer care officers, were not connected on internet to verify payment of taxes, but that the registrar would verify whether receipts for payment of stamp duty and registration fees has been attached. Have they attached payment? The state presented several receipts for payment of stamp duty and registration fees on various mortgages in issue. From the prosecution case, there was also attempt to suggest that less taxes were paid and did not match the value of the mortgages. PW7 and PW8 told court that the registration fees and stamp fees captured for the various transactions either were not suitable for the value of the mortgage or were not attached at all, thus causing the financial loss. On verification of documents or fees paid, that is how the evidence is. They seem to say it's not the duty of A4, 5, 6. But evidence is alluding that it was the role of the customer care and the registrars, that you had a duty to verify payment of taxes. But their purported problem, that's 4, 5, 6, is processing and registration of the mortgages that had not been formally received at the customer care desk without verification of payment of stamp duty. That is the problems for 4, 5, and 6. A1, 2, and 3, who presented oral testimonies, told the court that they had no mandate and capacity to verify fees paid to verify fees paid at URA, but their role was to verify documents presented to ensure that they meet the legal requirements. All counsel in their respective submissions maintained the same position and added that accused verified documents, and documents herein included the receipts of registration fees and stamp duty. 5, 7, and 8 alluded that customer care officer had a duty to verify payments on URA web portal and that he had internet for this purpose. Reference was drawn to communication made to ICT, which is Prosecution Exhibit 9. A2 denied this fact. PW3, the immediate supervisor of A2, stated that there was internet left for him for purpose of verifying documents. PW5 and PW8 could not confirm whether beyond the communication made to ICT internet was accessed by A2. Beyond that letter, they could not verify whether there was internet. PW8 was the IO. There was a front desk with internet customer care officers to verify payment of taxes, but in cross-examination indicated that whereas the connection was there, he was not sure whether it was connected to URA. Now this is the registrar who works in that place. He's not sure whether it is connected to URA, but it was placed there. Of course, without connectivity to internet, none of our accused had the capacity to confirm or verify the fees paid, but would only rely on the documents presented. These receipts were visibly presented and all were found in a file and captured on the land information system. PW7, the auditor from Auditor General, using the internet was able to make verifications and established that the receipts presented were forged as they did not tally with the barcodes and the PRN provided. He was also able to trace all persons who attended to every transaction as described in Prosecution Exhibit 19. He was right to find so because he had capacity to examine the land information system. He also had the capacity to access URA portal to establish whether payments were effected for every transaction issue, having written to URA to confirm as per Prosecution Exhibit 18. He also accessed National Land Information System as per Prosecution Exhibit 17 and reviewed the system using passwords assigned to accused persons for those transactions. He had the capacity. He accessed internet, which I accused did not. It would have been the same if accused also accessed the internet. They would be able to look at this and look at URA. They would results. They could also confirm that yes, what you have presented is not genuine. They would put there, but now they are not there. The fact that accused were registered on land information system as described by PW5 and evidenced by Prosecution Exhibit 3 to 8 did not mean that they had capacity to verify the payments. This role was left for only A2, but still there was no sufficient evidence presented that he accessed the internet to be able to access URA portal to verify the actual payments vis-a-vis the receipts presented. Equally, there was no proof to show that he was adequately trained for that particular role. Not the role of accused to pay the stamp duty, as per Client Charter Defense Exhibit 8 and Transaction Information Manual Defense Exhibit 9. PW6 presented employment records for each of the accused persons as Prosecution Exhibit 10 to 15. There was no particular assignment as to verification of URA taxes, but the aspect of any other assignment was provided in the employment letters. Such would qualify accused to take on any other duty once assigned, but the accused should be in a position to execute such assignments when directly told to do so. But the registrars and to verify the payments at URA. Other accused persons had no authority to do so, but the registrars could do so based on the scanned documents with the hard copies presented to them. A1 and A3 told the court that they based on the hard copies of proof of payments and passed the instruments. DW4 and DW5, the bank officials from Centenary and DFCU Bank, told this court that payments for stamp duty and registration fees for mortgages in issue were paid. These are officers coming from the bank now, saying that those payments were made. The documents were not presented by PW8, the IO. When DW4 said, when I was summoned, I took them to the police, proof of payment. But the IO in this court did not talk about them and did not also present them. The state also ignored to present Kaso Tibangani, whom the bank also said was instructed to pay stamp duty and registration fees for some of the mortgages in issue. Indeed, if it was the issue of causing financial loss, the state would have made a step to bring such witnesses to testify or to be joined as co-accused. The net effect of not calling a vital witness or document like in the present case was discussed in the case of Bukenya and others versus Uganda, 1972, Volume 1, EA 549, where court did hold that a decision of a party not to call a particular witness or person as a witness, whose evidence is material, particularly and uniquely available to that party, where there is no reasonable explanation for the failure to testify or attract an adverse inference that the witness did not testify because the testimony would have been adverse to the interest of the party who otherwise would have been expected to call the witness. Notably, it was also confirmed that accused were not responsible for payment of taxes, but was to be done by the mortgagees and transferees. The cases of Bukenya are not responsible for payment of taxes, but was to be done by the mortgagees and or transferees. None of the alleged mortgagees or transferees were presented to deny or admit to have paid or not paid their taxes. These are vital witnesses. The accused herein did not do an arbitrary act, in my view. They performed their duties as expected of them. The procedures were followed. They were not expected to pay the registration fees and stamp duties. They did not prejudice their employer, and they did not occasion the loss alleged against them. The only fault the state raised against accused is that they failed to verify the receipts presented for the values of the various mortgages. But the defense case is that the receipts were presented for the values of the various mortgages on record, that save for A2, whom authority was granted to verify, the rest of accused also could not do so, and even for A2, it was not proved that indeed he was given internet and thus had the capacity to access URA portal. Needless to say, as clearly stated by PW5, Wakiso Land's office was on the first phase of Land Information System, which was not interlinked with URA. Other do not access other MZOs to verify the taxes, whether they are being paid in respect of associated mortgages or not. Now, for these other registrars and other staff, completely for them, they were shut off from internet. So they could not verify from URA any payments, but the obligation was to verify the documents presented to them and whether they passed the legal test. Other officers equally had no capacity to also verify payments in other MZOs, but also DW6 and DW7. The registrars from Mukono, MZO, and Wakiso Chadodo were able to prove that some of the mortgages in issue were first registered in their MZOs, and the registration of instruments issued needed not be paid for again because it was not allowable. Unfortunately, again, the IO ignored this step to find out whether payments had been done in other MZOs or not. He did not visit other MZOs to verify this fact. He entirely based on the report of the auditor to charge accused persons. Overall, the system was under test, rollout, and not comprehensively aligned to perform the intended purpose, such as verification of taxes by a customer care officer to hold that he had failed to perform his duties. Equally, the rest of the staff had no capacity to verify any payment. Many gaps still existed to allow accused to do any verification of taxes on the system as it was intended. Had the system developed and staff well trained, probably they would be held liable. PW2, 3, and 4, who are senior officers, clearly said that the system was not well established and used, but it had been installed. An attempt to demonstrate verification of taxes was conducted by PW5 in cross-examination by counsel for A2. But still, PW5, the expert herein of the system, failed to get the corresponding values. On the issues of whether A3, 4, 5, and 6 processed and registered transfer instruments which had not been formally received at the customer care desk and without verification of payment of stamp duty, DW3, who is A3, did state that all transactions he worked on were taken by the front desk officers as per practice direction presented as Defense Exhibit 13 and Defense Exhibit 3A. Under the law, to have a receiving stamp, that it was not provided as a requirement under the law to have a receiving stamp on the document, but what was required was for the receiving officer to issue out an acknowledgement of receipt to a person depositing the documents. That the stamp was not important for him to outline the procedure for receipt of instruments or documents and referred to Defense Exhibit 3A regarding the receipt and management of deposited documents at the MZOs. He also referred to Section 196 of the RTA. The understanding of these provisions is that person receiving documents shall issue a printed form listing the documents received. He submitted that under Prosecution Exhibit 19, in brackets 13, there was proof that F4 attended to the transaction and there was no need for him to look at the received stamp. When we look at 13, these are the transactions each one performed, which the lands officer extracted. So it is not doubt that these people performed the roles, they entered under lease, that F4 had no duty to verify stamp duty because was not a customer care officer, that was not his role. But he performed a function to enter it into the lease system. And therefore that F4 did not cause any financial loss. That he did not know that the transferees had not paid the stamp duty. He submitted that PW3 contradicted himself on the issue of receiving stamp, and so was PW4. He also asked court to reject expert opinion, or PW7, that both copies of the posted document has to be received on with a stamp. That PW8 and PW7 relied on interview X3A and Section 196 of RTA. It was not necessary to have stamp impression according to the practice direction and Section 196 before he could pass it. It was his testimony that all transactions before him met that legal requirement. I must say that PW7 and the PW8 relied on hearsay. Those who told him this is what we do, but they were not called. So they relied on hearsay, but they did not brush themselves with the relevant laws and practices. Failure to present Achom Esther, a data entry clerk, like A5 and A6, was detrimental on the part of the prosecution. In the result, I do not find the prosecution to have proved that accused herein did arbitrary act. There was no loss occasioned by them, as they had no obligation to pay the said taxes. In light of the above, I wish to pin that this trial was a mistrial because all persons responsible for paying the registration fees and stamp duty were not charged or presented as witnesses. There are people who are supposed to pay. These ones were not charged, neither were they presented as witnesses to confirm otherwise. The system was not yet interlinked, emphasis, with URA to enable A2 or other officers to access it for verification of taxes. I do not find the accused liable for the financial loss in all accounts on each of them because To do so would run a risk of placing on the registrars and staff thereof a duty to pay stamp duty. And if I found so, I would still have ordered for the compensation of the losses, yet these losses were meant to be paid by the mortgagees and the transferees, not the accused person. It was purely the duty of the mortgagees or transferees to pay such taxes, and if they presented receipts to be forged, they would be held liable. These are traceable persons who would be summoned and answer to such allegations. There appear to have been some receipts on files on which the registrar relied on to register the mortgages or transfers. Whether they were forged or not, the registrars did not have capacity to establish whether they are genuine or forged. They were not connected to URA portal. The issue of a stamp, certificate, or receipt, in my view, was not what was important. What mattered is proof of payment for them. I agree with the PW7. Since the available payment receipts were not captured in the URA data, that notwithstanding, I need to state that this loss was occasioned by the mortgagees and transferees who presented the forged receipts to Wakiso MZO officials. In the result, on the basis of the analysis and evaluations made, I do not find the prosecution to have proved every element of the charges against accused persons. All charges of abuse of office and causing financial loss against each of the accused are dismissed and the accused acquitted.
The first prayer is that since the accused persons have been on bail, I pray for an order for their bail refund. To your worship, these accused persons are government employees. They have not been. I pray that they have been on half pay. I pray that an order be made that their withheld salaries are paid in full, and an order for reinstatement if their contracts are still subsistent. I so pray, your worship.
The issue of bail refund. These are consequential orders the council is asking for. Okay.
You sweat, but it is the same way. The other part is not arranged to the